What happens when a judge gets things wrong and a judge's actions create child abuse, facilitate child abuse, empower child abuse, excuse child abuse? And most people would say, well, the judge should never be allowed to permit any type of child abuse. The judge should never partake in child abuse. That's what I want to discuss right here in the case called Stump v. Sparkman. And this was argued back before the Supreme Court, the United States Supreme Court, January the 10th, 1978, and it was decided March 28th, 1978. But before I go into that part, I want to talk about what happened at a different level. I probably will not get to the whole thing today, probably will be a couple of days before I get to finish this. But here are the circumstances that took place regarding Stump v. Sparkman. The mother, and the mother's name was Ora Spittler McFarland. Her daughter Laura had been going out on occasion with different men, and Ora did not want to have an unfortunate circumstance take place. She did not want the daughter to get pregnant. So she went to a judge and she had an affidavit and said, you know, Judge, I want to have my daughter sterilized. She's 15 and she's somewhat retarded. And the circuit judge, and his name is Judge Stump back in Indiana, he approved the petition. He had an ex parte proceeding, no hearing, and without notice of the daughter, and without an appointment of a guardian ad litem. So shortly after the judge signed off on this, sterilizing a 15-year-old girl who might be perhaps promiscuous, who might perhaps be somewhat retarded, who might have a child, they took the daughter into the hospital and they lied to her. They did not tell her, hey, we're going to stick you in here, we're going to tie your tubes, we're going to sterilize you. They told her she had to have her appendix removed. Instead of having her appendix removed, she had a tubal ligation. She was sterilized for life by her mother, and the judge signed off on it. No hearing, no due process, nothing like that whatsoever. So approximately 2 years later, Laura gets married to Leo Sparkman, and they try to get pregnant. And they're not having any success getting pregnant. Should be very fertile, but she's not getting pregnant. So she goes to the doctor and she finds out, lo and behold, she has been sterilized. She has had her tubes tied, this by an order of a judge. The daughter had no say in the matter. The daughter was underage, 15 years old, but the judge and the mother basically said, hey, that's a good idea. Let's have her tubes tied. So she filed a suit in the federal district court against her mother's attorney, the circuit judge, the doctors who performed or assisted in the sterilization, and the hospital where it was performed, seeking damages for the alleged violation of her constitutional rights. So it turned out that when this case was filed, as I understand it, that they said, well, you can't sue the mother, you can't sue the attorney for the mother, you can't sue the doctors, you can't sue the hospitals, because here they had a court order. They had something signed off by the judge. So he was the only person that was allowed that they could sue. But lo and behold, we have this thing called judicial immunity. Judicial immunity means that a judge can intentionally make a bad choice. A judge can erroneously make a bad choice. A judge can abuse a child and still claim immunity. He cannot be prosecuted because we want our judges to be independent. We want to make sure that they have all the tools at their disposal, that if they need to use them, they can use them without fear of being sued. So it turned out that the only person that was able to be sued was Judge Stump, and he was absolutely immune from suit under the doctrine of judicial immunity. Judges can actually do things that they know will destroy a child, or that may be an exercise of vengeance against a parent. It may be exercised out of malice because somebody has criticized him, and they can claim judicial immunity because they are acting in the accordance with their judgewomanship. They're making a judicial decision, and nothing can happen to them because we want our judges to be independent. We want to give them all the weapons, all of the tools that they need to exercise their judgments properly, even if their judgments violate constitutional rights, such as the fundamental right of due process. Linda and her husband Leo sought damages for alleged violation of Linda Sparkman's constitutional rights. Also asserted were state claims for assault and battery, medical malpractice, and loss of potential fatherhood. The Sparkman sought to hold the private defendants liable on the theory that they had conspired with Judge Stump to bring about the allegedly unconstitutional acts. And for anybody who knows what takes place in family courts, this is not a far stretch. We know that conspiracies take place. We know that there are pretrial hearings in which the judge and the attorneys basically have predetermined outcomes. They go through the whole charade. They don't want to show their cards before it takes place, but it's a charade in many instances. And they were saying that there was a conspiracy here that took place between the mother's attorney, and the judge. The district court, however, held that no federal action would lie against any of the defendants because Judge Harold Stump, was the only state agent, and he was absolutely immune from suit under the doctrine of judicial immunity. So going to this doctrine of judicial immunity, what it says, once again, is that if a judge makes a decision that is an error, he is immune from any type of prosecution. How can you have a judge make a decision if he might be sued for his decision if it were erroneous? We can't allow the judge to be sued for any reason at all. We have to have this doctrine of judicial immunity. Even if the judge is violating your constitutional rights, even if the judge is committing crimes from the bench, the judge has to have judicial immunity. Judges have full immunity so they can conspire with attorneys, they can conspire to commit evil, they can conspire to deprive you of your constitutional rights, and they are immune from prosecution. How about that, huh? The court stated that whether or not Judge Stump's approval of the petition may, in retrospect, appear to have been premised on an erroneous view of the law, Judge Stump surely had jurisdiction to consider the petition and to act thereon. Well, anyway, I will talk about the appeals next time around. I don't have the time to do this right now. I do want to talk about the appeals, and then I want to talk about it going to the U.S. Supreme Court. On appeal, the decision of this court was reversed, and Judge Harold Stump was shown to be liable. And then I went to the Supreme Court, and the Supreme Court, by a vote of 5-3, with one person not participating in the discussion, actually held that the doctrine of judicial immunity should be maintained. Judge Stump gets off the hook. And if you think that this is just something from the past, this is happening today as well. Dallas, Texas, we have Judge Mary Brown, who is allowing orders, permitting orders, facilitating child abuse of James Younger, facilitating child abuse of a 9-year-old boy, empowering it, granting the mother the ability to socially transition and later to chemically and perhaps even physically castrate her son. She will probably claim judicial immunity. And of course, the mother will not be liable because the only person liable would be the judge who has permitted this. And the judge has immunity. The attorney, Jessica Janasek, the child castration attorney, who was advocating for the mother to make sure that James will be socially transitioned, to make sure that James will be chemically castrated and probably physically castrated in the future. Jessica Janasek of the Coonsville Law Firm, she will not be liable for anything. The mother will not be liable for anything. If they go to California, as they are intending to do, and go forth with the procedures there, the doctors there will not be liable for anything. The hospitals will not be liable for anything. Governor Newsom has permitted this over there in California, and the legislature over there as well. This is taking place today. And if you go to court and you say, I don't understand what happened, it's because you can be deprived of your constitutional rights. You can be deprived of due process. And the judges know that they can do this stuff. They can work with attorneys that have paid them handsomely for their campaigns. They can work with law firms that have supported them during their campaigns. And they can rule in their favor. Whatever the argument is, it means basically nothing. This is what is taking place in our courts today, especially our family courts. We are permitting judges to commit, to encourage, to facilitate, to empower child abuse under the guise of acting as a judge, and they get judicial immunity, and nobody can be sued. This is what is happening right now, currently, in the state of Texas as well. Stump v. Sparkman argued January the 10th, 1978, and decided March the 28th, 1978. You should take a look at this case because this is being used against you as you fight for your children in anti-family courts, being used against you by anti-family judges, anti-family attorneys. People with the most money tend to win. Why is that? Judges know that even if it's proven that they've made a decision based on what an attorney has perhaps even bribed them to do, they have judicial immunity. That's how hideously evil this whole doctrine is. We need to be reviewing judicial immunity, and we should not permit this judges to commit child abuse simply because of judicial discretion and the doctrine of judicial immunity. Thank you.